Hi, good evening, everybody. I'm going to speak about what I've tried, okay, because all these cases have been attempts. I never knew what was going to happen, especially with the first case that I introduced when I was a third-year law student. It's 5 years in Costa Rica law school. So by the beginning of third year, you really don't know much. And but it didn't prevent me from trying, you know. And for good or for worse, it happened to result. So I'm going to talk about these cases. I'm going to talk a little bit about Costa Rican history, so you understand a few things. And we're going to talk also about the right to peace. That there is a right to peace, and it does exist, and it's international. And we're going to start there by asking ourselves, what is the right to peace? Because all of us have a definition on the right to peace, and all of our definitions are okay but incomplete. All of them. All of them. Even my own definition that I have right now is incomplete. And it brings us in the practical matter to the question on whether or not we can define peace or whether or not we want to define it. You know, because once you define something, it gets stiff. Yeah, and it's not so difficult, not so easy to keep working on it. And then you can understand that as many other legal concepts, they evolve. You know, and the threat to peace depends on how the evil minds evolve also. You know, there are new threats to peace every day. Right now, we have the drones. We didn't have the drones 10 years ago. So, as an evolving concept, all definitions will become obsolete with time. It's an abstract concept, it's comprehensive, and it's transversal. It does affect every single activity of our lives. It is easier maybe to say what is not peace. And probably all of you are going to say, yes, violence and war and threats. But it's much more than that, because we have structural violence and social violence that does not manifest in a physical activity or a physical harm to people. And this is something I've been learning in these recent years. I mean, I've been working on this topic for 10 years already. And I found out that we had this old conception that just war and peace are just antonyms. But it's much more than that. So, contradicting myself, I tried to bring some sort of not stone-written definition that peace is a state in which all human rights are fulfilled in an environment free from fear and want and violence. You know, because if we don't have the fulfillment of all human rights, equality, housing, education, healthcare, good taxation, not confiscation, some property rights, if we don't have these, we have a very violent society. And conflict is there, just waiting for the moment to come up. It's a tough thing, actually, to achieve peace. I don't like talking behind the desk, so I just want to turn this away. So the evolution of the human right to peace in Costa Rica actually did not start with the abolishment of the army. It's a very interesting story because, as you might know or not, every single Latin American country after independence elected as a first head of a state a military man, a tough man to lead the country. But Costa Rica, we elected an elementary school teacher. This is 1821. We didn't have a printing press. We brought a printing press. We drafted our first constitution in 1824. And in this constitution, the president, as a school teacher, understood the value of education, and he declared in the constitution education mandatory and paid by the state, same as healthcare in 1824. Right? And and the history of Costa Rica is full with funny contradictions, because we had a coup in 1846, and the dictator came in. And this guy, Braulio Carrillo, in 1848 issued the new constitution of Costa Rica that had a Bill of Rights that is just like reading the 1948 Universal Declaration of Human Rights, a century ahead of it. In 1871, Costa Rica became the second country in the world to abolish death penalty. After, somebody knows who was the first country to abolish death penalty? Venezuela. In 1871, the last military man to run the president office in Costa Rica prohibited the participation of military men in elections or political affairs. A military man prohibited other military men to participate in politics. And then the story went by, and then we had the revolution of 1948 due to a fraud in the elections, and it ended up with the abolishment of the army in 1948 by decree that was incorporated in the 1949 Constitution. After that, in 1969, in Costa Rica, we drafted and approved the Inter-American Convention of Human Rights, known as the Pact of San Jose of Costa Rica. And in 1983, President Monge, due to the pressure of the CIA and the US Embassy to let America train Contras to fight against the revolution in Nicaragua, under that pressure, he just said, oh, and he had a brilliant solution. He said, I'm going to acquire an international obligation for the country that will prevent me legally to give them the permission they want. So he declared Costa Rica neutral. And then he said, I'm sorry, CIA, but I'm neutral. I can do nothing. And that was a brilliant move, you know? And afterwards, in 1998, Congress passed the alternate conflict resolution law for the promotion of social peace. So it's quite a long story of peaceful activity, you know, aimed at keeping us away from the conflicts that were happening in the region. Because every other single country in the region, especially in Central America, was under war since the 60s until pretty much the 90s, early 90s. Now, in court case law, we have two stages, and that's why I named the presentation Evolution, Practice, and Obstacles, because things changed in Costa Rica due to the evil mind of Oscar Arias. And before Oscar Arias came into office in his second term, we had a very functional judiciary. It was independent, and it would rule pretty well. So in 1992, actually it was a resolution from 1992, the court declared that the value of peace was a founding principle of the nation. We're going to go over that later. Then in 2004, they ruled the Iraqi war case that we're going to see. All these cases, we're going to go through them afterwards. And then in 2008, we had the case concerning the arms decree at constitutional court level. We had also the forbidden arms decree, of which Marta talked about, for authorizing the police to use military weapons against protesters, that was tried at the administrative court, and that case was also won. And then we had the dysfunctional constitutional system from 2007 on, where they just refuse to try any of my cases anymore. So we have the CAFTA case, the US Navy permits case, and the School of the Americas training case. And the CAFTA case is probably the most ridiculous of them. I'm going to tell you afterwards about it. I always take a time to make a few clarifications, because not only I was able to do what I have done because I'm ill-tempered and stubborn, but also because I had the legal remedies. I mean, there were the legal remedies that I could use, to file these suits. For instance, you don't have the right to go before the Supreme Court and request the declaration of unconstitutionality of a law. Well, I can. And here is something you can start working on. We got to introduce legislation that should allow you to, stand by the Constitution. In the end, the Constitution is supposed to be the reflection of the society, of the people, the will of the people. But we're blocking the people to actually make their will come true if we don't let them access constitutional justice. It's the most fundamental legal document in a country, and you have no access to constitutional justice whatsoever, which is outrageous, at least to me. So I always make this clarification that there were and there are the mechanisms in Costa Rica that allow us to demand justice at constitutional level, not just a matter of legality. So in March 19, 2003, as you remember, the US-UK-led invasion decided to start bombing Iraq. Against international law, the UN never authorized that invasion. Resolution 1441 never authorized that invasion. And right at the moment that the invasion began, the Costa Rican president came out on the media and said, "We are supporting the coalition of the willing." And next day and the following day, some polls were run in order to get the opinion of the population on two questions. Do you support the war on Iraq? Or do you support Costa Rica supporting the war on Iraq? And the numbers for the no were 99.2 and 99.6% of the population against the decision of the government, which was very good for me, because now the court had no other choice but to rule in my favor, politically. Because these constitutional courts are not just bodies of legality. And you have a perfect example with your own Supreme Court. It's a political body. It's a political body. They rule on politics, and sometimes they rule on nonsense. For instance, the resolution of the Supreme Court saying that international law is binding to the federal government but not to each state. Okay, so I don't get it. So several things came out of this case. And the first important thing that came out of this case relates with the Acts of State Doctrine. Is any of you familiar to the Acts of State Doctrine? Okay. The Acts of State Doctrine says that there are some political acts made by the government that escape jurisdictional control. Political declarations, declarations of war. But this doesn't really make sense in countries that have a principle of constitutional supremacy, like basically every country in the world, right? Because if the Constitution is the supreme law of the nation, every single activity performed by government officers or even individuals has to comply with the Constitution. Arbitrariness is not a right of the government. No? Okay, in this case, because this act of state doctrine had been going on for about 150 years, but we found in the Iraqi war case one of these limit cases that make changes, because the court had to rule that act of states were not beyond jurisdictional control anymore, because they had to annulate this one, and they had to, and they said there is no objection to the possibility on constitutional check of such acts released by the executive. There is no objection. There is nothing in the Constitution that says that you cannot actually try acts of a state. And this was the first important outcome of this case. Now the government just cannot do whatever they want, even at a political level, right? That was the first good thing about the case. After that, the neutrality statement was promoted to constitutional rank. In Costa Rica, we have a very complex constitutional system because we have a written constitution and we have a non-written constitution. There are 3 countries in the world where if you go to a bookstore and you try to buy a constitution, you're not going to get it because it's not written. It's the UK, Israel, and New Zealand. So the non-written constitution is the accumulation of all the resolutions from the parliament, the Supreme Court, that over time had been repeated and reaffirmed. And it's not easy because it's very much in the cloud. You know, it's very abstract, but there are sources and documents that can actually, you know, get you to give some body and context, a specific body and context to this non-written constitution. So the Supreme Court promoted the neutrality statement to constitutional rank. So it was just not another international law obligation under the theory of unilateral acts of a state, because also you don't declare yourself neutral to yourself. I mean, a declaration of neutrality is clearly a declaration that is meant to have international effects, not just domestic. And that was also pretty good. Then the court ruled out that since Costa Rica is a member of the UN and the Costa Rican Constitution says that international law that has been approved and ratified by the Congress is binding, as every other constitution says, then the government had to comply with the proceedings established in the UN Charter because we joined the UN. And since the Security Council never authorized the invasion of Iraq, the government was violating Article 7 of the Constitution and international law at the same time. Even for the case of moral supports, as the government claimed that they were giving a moral support, I've never seen anything as immoral as supporting such a war like the one on Iraq. And so this was another important outcome of this case, because this is what happened. When I wrote the suit starting 3rd year, I didn't know much about law, you know, international law, constitutional law, any law. I didn't know much, but when the hearing took place a year and a half later, I had gone through constitutional law classes and international law classes, and every single word I said at the hearing was related to international law. I did not speak one word on constitutional law, and the government was not prepared for that. All their arguments were based on domestic law. And the Costa Rican Constitutional Court has said in 1995 that international human rights law instrument in the Costa Rican system have a rank above the Constitution. Now, legally and technically, this is absurd, but practically, it's very good. I mean, it helps a lot. And I'm always going after the Supreme Court because they write these resolutions not really on the topic. But on this specific case, I'm cheering for the Supreme Court, you know, because it helps a lot. It doesn't matter how nonsense it is. In this specific case, the court refused to recognize peace as a right. They kept saying that it's a fundamental value of the nation, that it's a founding principle of the nation, that it's a core value of the people, but the word right was not there yet. This specific part of the case was important because from here on, it was clear that we could apply international law domestically, in domestic courts, something that doesn't really happen that much, unless it's corporate business, property things. But in terms of human rights and other international public law, it is usually not applied domestically. And there is nothing that prevents us from doing so, because the Constitution says that international obligations ratified by the Congress are binding to the country. As a result of this case, and the final paragraph of the resolution is this. So they annihilated the support and they ordered the Costa Rican government to withdraw the support and to withdraw the name from the coalition of the willing. Thing that happened just 3 days after the ruling. Colin Powell sent a fax to my house saying, I hate you, but Costa Rica is not anymore in the list. So, well done. I wish we had these modern faxes that are printers, because we had the old ones that delete with time. So it's quite a pity because I don't have that document anymore, but it has to be in the federal records, or yeah. You should be able to get it if you want, I guess. Okay, after that, we have the Arms Decree case, and it was issued during the first month of Arias' second term. Yeah, the same guy that won the Nobel Peace Prize. Yeah, the same guy. And he authorized this. The worrying part about the first activity is that it means that we do have uranium in Costa Rica. That is very much worrying. Well, the manufacture of nuclear fuel, let's leave it there, but then the manufacture of steam generators, excepting hot water boilers for central heating. This class includes the manufacture of nuclear reactors for all purposes. I didn't go to no fancy school to learn English, but I understand that all purposes is all purposes. And whether we want it or not, war is a purpose. No? And for those of you who doesn't know, a nuclear reactor is a steam generator. That's what it is. So I went back to the Supreme Court, and with a little bit more knowledge now, I did this exercise. In international law, we have something that we lawyers call the customary rules of international law. And for your legal system, this might not be something crazy because you work on common law. And it's a lot of case law. So it's a lot of custom going on in your legal system. So these customary rules of domestic law says that whenever a country has repeated acts during time towards acquire certain obligation, and they ratify these acts by a manifest intention to acquire certain obligation, an international obligation is created. So we had these two elements that we got to demonstrate, and countries demonstrate in the ICJ in The Hague, for instance. the nuclear test case, Australia and New Zealand against France. What happened in this case? France was doing nuclear testings in the South Pacific. And Australia and New Zealand were complaining and asking France to cease these testings. So the president of France came to the media saying, okay, it's fine, France is going to stop testing in this date. And they didn't. So the International Court of Justice said that as a representative of the state, as a plenipotentiary, you cannot just come out and say stuff. I mean, if you say something with the intention to acquire the obligation, then you got to comply that obligation. So what I did is that I tried to use this mechanism to demonstrate the existence of a customary rule of domestic law. So I brought a Costa Rican history textbook, I gave it to the justices, and I said, okay, read our history, and read the neutrality statement, because the neutrality statement is that act that made manifest the intention of Costa Rica to acquire an obligation towards peace. So I said, okay, according to this theory, the obligation has configured, and the right to peace is an obligation created by practice and by the manifest will of the country. And the court bought it. And they promoted now the right to peace to constitutional right. And now I'm going to go to the ruling, because I always like to read this ruling. Okay, it cannot be more clear. It says, on the right to peace. It's the first time the court actually wrote right to peace. True as it is that the Constitution refers to peace, it rules on its concert and negotiation as part of certain functions of specific offices, yet the reach of this concept has been recognized and potentiated by this court's jurisprudence. On the issue, the court has pointed that it is a supreme principle of the political constitution and a core value of the Costa Rican identity. Moreover, it has been considered as a value both of domestic and international hierarchy. So it's international, which means that you should have that right too. Derived from the text of the United Nations Charter, the Declaration of the Right of the Peoples to Peace, and other international documents. And then they quoted this part of the Iraqi war case. It is evident that the people of Costa Rica, tired of a history of death, clashes, dictators, and margination from benefits of development, decided from 1949 on, free and wisely, self-determination, collect a principle cherished long among Costa Ricans and adopt peace as a guiding principle of our society. On this date, a historical turn takes place, a new spirit is proclaimed, a spirit of peace and tolerance. From there on, military headquarters symbolically transform into museums, learning centers, and the country adopt reason and law as mechanisms to resolve disputes in and out of the country. Furthermore, a bet is taken on human development, while the right to live free and peacefully is proclaimed. On that day, the nation changed. We decided that any cost that the pursuit of peace could bring would be always far lesser than the irreparable cost of war. This philosophy culminates on our perpetual, active, and non-armed neutrality statement and the numerous international instruments signed on this sense, as extension of that deeply rooted constitutional principle which arises as constitutional parameter for the legality check of the challenged acts. This court jurisprudence has ruled accordingly, highlighting peace as a legal and political principle by stating from there that the laws in general, the rules and acts of authority required for this validity, not only having been promulgated by competent bodies and due process, but also passed the revision for its compliance with the rules, principles, and highest values of the Constitution, such as order, peace, security, justice, freedom, etc., which are set as the standards of reasonableness. It is very clear to me that the court actually took history into account. And they did have the exercise of applying these international public law mechanisms domestically, which is a very interesting exercise because this is not the normal thing that happens. And the effects of this naive attempt, if we want to call it like that, were outstanding. I mean, and I don't like talking about my cases this way, but I just cannot deny the importance of these cases. So while peace was, right to peace is recognized and promoted as a constitutional rank, the right to peace was also established as a positive obligation. Here, the court made a very interesting exercise because they tried to give content to the right to peace that has just been proclaimed. And they said that a state accepting peace as a fundamental constitutional value might not conform to the limited notion that peace is the absence of war, but must go further, preventing and continuously rejecting every decision and action that can encourage and lead to such circumstances. Certainly, among the activities that can be considered opposed to a pacifist spirit of a nation or country is the manufacture of arms and the production of certain minerals and chemicals. They are directly linked to violence, even in circumstances of legitimate defense. There are even certain types of weapons that are manufactured specifically for the use of war. In war, therefore, a country wishing to promote peace both domestically and internationally must take care to restrict the manufacture and/or import of weapons and chemicals in their territory, flatly rejecting those that by their nature have been thought and created to promote the negative value of war. So the court talked about both positive and negative obligations. Okay, a negative obligation is this obligation in which you should refrain from doing something, and a positive obligation is an obligation in which you have to do something. Okay, so they say, okay, as a negative obligation, you have to refrain from getting involved in these activities. And they went further. And they said that Costa Rica has to refrain to get involved in any activity of import, export, design, transport, stockpiling, manufacture of any item that is meant to be used in a war, which is a lot of stuff. And as a positive obligation, they basically preach on the government, and they said, okay, if you're going to go to the international forum and talk about peace and how peaceful we are, you got to mean it. You got to engage and you got to get involved, and you cannot just keep going outside of the country giving these beautiful speeches that are just empty words if you don't materialize them. Which was a very interesting effort by the court to try to give some content to what was the legal effect of declaring the existence of the right to peace. One interesting thing about this case is that I never claimed that weapons of mass destruction were a violation to environmental law. However, the justice that wrote this ruling is an expert on environmental law. So he thought important to include that, nuclear weapons are a threat to the right to a healthy environment. Article 50 of Costa Rica's Constitution says that everybody has the right to a healthy and ecologically balanced environment. So the justice ruled that the production of these items and, the extraction of uranium and the radioactivity and all this stuff is a violation to the right to a healthy environment. Moreover, because you cannot control the area that is being affected by a weapon of mass destruction, you're exposing the nature to the effects, to unwanted effects, or what the U.S. government called collateral effects of the use of these weapons. And here is basically what the court said on this. Now, the court annullated the decree, and this was in 2000, and the ruling came out in 2008. Now, during this time, and if you remember the slide when I talked about the dysfunctional constitutional system, it began in 2007. But this ruling is from 2008. I thought that this ruling was going to be rejected, not because of legal grounds, but because of political matters. And there is something I gotta tell you about why I'm saying this. Oscar Arias was president of Costa Rica from 1986 to 1990. And the Costa Rican Constitution was amended in 1968 to prohibit re-election. And after many talks of Arias with the U.S. people, the embassy, and politicians, they decided, not just him, that it would be fantastic to put Arias into office again. So Arias went to the Supreme Court and challenged the legality of the amendment in order to revert it so he could run again, because in the original 1949 Constitution, re-election was permitted once after 2 terms. He went to the court ruled against his claim, saying, no, the amendment was done following the procedures established in the Constitution, and is completely legal. His party was had the majority in the Congress. And in Costa Rica, the Congress is the one that appoints Supreme Court justices. So suddenly, 3 justices were kicked out of the court, and 3 new justices were put into their places. And according to the law on constitutional jurisdiction, you cannot try the same case twice. And the court has not tried any case twice but this one. And now they ruled that the amendment now was unconstitutional. So Arias ran again and did not win, but he made it into office, just like Bush the first time. Same thing, So I thought this suit was going to be rejected because it would touch Arias's beloved peace dove and his reputation and all that stuff. He got actually quite upset with me. So I won this case, fantastic. In the meanwhile, the CAFTA process was taking place, the Central America Free Trade Agreement, the U.S. Central America Free Trade Agreement. And the court was rejecting all the claims of unconstitutionality because the CAFTA was the only policy of Arias' second term. And he came out on the media, and when he took office, he said, I'm here only to pass CAFTA. And he really didn't care about anything else. So the court issued the advisory opinion on CAFTA saying, no, it's not unconstitutional. The ombudsman had some complaints about some weapon clauses and so on. And CAFTA was finally passed in 2009. This ruling came out in 2008. And is binding. So in 2009, CAFTA was passed, and every country participating in CAFTA had the right to make annexes. These annexes would set the list of specific items that were of a specific commercial interest for the country. Okay, this is Costa Rica's Annex 3.3. Not any other Central American country included these items in their annexes. Only the peaceful and peace-loving country of Costa Rica. Now, if I don't remember very bad, that thing was declared unconstitutional, right? So, well, I was suspicious about the Supreme Court by that time. So I did something that this is probably the only thing I would say was really, really smart to do. So I filed purposely the wrong type of suit against CAFTA before the appropriate legal moment to do so. Right? In order to challenge the legality of a law or a treaty, you have to wait until this law or treaty is finally passed. Okay? So I submitted it ahead of time, and the court said, no, you just don't know nothing. This is not an amparo recourse. You got to submit an unconstitutionality action, and you cannot do it now. You got to wait until CAFTA is passed. Fantastic. So I sat on a chair, I waited, and CAFTA was passed, and I went to the Supreme Court with an unconstitutionality action. And I said, there you go. And they said, we are very sorry, but it's too late. Just like that, with a straight face. Late. Huh? So this case, I actually took it to the Inter-American Commission of Human Rights because it's obvious that there was a denial of my access to justice. You just cannot tell me, wait a little bit, oh, too late. The court, because if you want to look at this way, the court ordered me to wait. Not because I wanted to wait, they ordered me to wait. And I complied as a good citizen. You know? And they just said, we're just so sorry, man, but you just came late to this party. And however, the arms decree case and the case I have in D.C. is preventing the country to start manufacturing these weapons. Raytheon had already bought 5 hectares of land in Costa Rica. Raytheon is this company that makes the Tomahawk and all these sort of weird-ass things to kill people. So the whole thing is this. With the coming of the UN Charter in 1949, at the end of World War II, they created an organization that was made by the will of the people, and the UN Charter starts with "We the people of the United Nations." So it was meant to be an empowering tool for the people, clearly stating that rights of the people shall not only come from domestic law but also from international law. And the clear example of that is international human rights instruments. It's international law that applies domestically. Then it's clear that there is no difference with international public law and international human rights law. Well, except in the United States somehow. That has refused to adopt the most basic declarations, you know, the International Covenant and Economic, Social, and Cultural Rights, the Covenant on the Rights of the Child. I mean, only China and the United States had not ratified the Convention on the Rights of the Child. Only China and the United States is the only 2 countries in the world that did not ratify the Convention on the Rights of the Child. And whenever they had ratified an agreement or an instrument and they are sued before the International Court of Justice, they just don't show up. As it happened in the case of Nicaragua against the United States for paramilitary activity in and against Nicaragua. So Nicaragua filed suit. The United States said, no, you don't have jurisdiction, you know, to try this case. The court ruled, no, we do have jurisdiction, and the United States, okay, then you have your own case because I'm not going. Nicaragua won the case, and the U.S. used the other mechanisms that they have. They removed Ortega, and they put Violeta Barrios de Chamorro. And even when the case won, Violeta Barrios dropped the suit at the International Court of Justice. It was at the stage of execution and reparations. This reparation was not for the Nicaraguan government, it was for the people that had been killed and tortured and the families that had been destroyed and torn apart by the war. And with a straight face, she went to the International Court of Justice and says, no, we're dropping the case. Just like that. So that was just a parenthesis on what I was actually saying, a big parenthesis. So the whole thing is this. These cases have demonstrated the possibility of utilizing international law domestically. And it's very important. Any case I bring to the Supreme Court, I do not write a word on domestic law unless it's strictly necessary. But I go to international human rights instruments because the court very wisely said that they were above the Constitution and that they were binding. Specifically regarding peace clauses, and this is the topic of my thesis, I said there are certain obligations because traditionally, by excellence, the Constitution is a document that shows the will of the state, but it's a domestic document. Yeah, it's never meant to have international effects. But what if we look to certain specific clauses that don't have the intention to create a domestic obligation? For example, peace clauses. I mean, unless I'm going to the church, I don't declare peace with myself, you know? Or I'm going to the mountain to meditate, and then I find peace for myself. But regularly, a declaration of peace is not for the countries, for the other countries, just like the neutrality statement, which is a peace clause. So I've been working on this thing in order to try to convince some government to use the Costa Rican Constitution to help me with the cases internationally, to sue Costa Rica based on our constitutional law. I have not succeeded on that, but I tried. Now, in order to go to the next case, because this is now we are in the sad part of the story where the court is just non-functional. In the last 15-something years, some changes had happened in South America. I'm not going to say that it's good or it's bad. I'm just happy that the people had been able to self-determine themselves. So U.S. military bases were closed in Uruguay, Argentina, Ecuador, Bolivia, and certainly Venezuela. That's a lot of military men that you gotta allocate somewhere. Afghanistan was not a choice anymore. Iraq was not a choice anymore. And Costa Rica has a very, very strategic position in the continent. We are this tiny little thing here, right here. Okay. Caracas is here. Cuba is here. Colombia is right here. Ecuador is right here. And Costa Rica happens to have an island somewhere around here. So the Costa Rican waters are actually huge. So see, Ecuador is somewhere around here. Now, Colombia is somewhere around here. And where do we get the cocaine from? Well, not me, but the people who consume cocaine in the United States, which is the #1 consumer of cocaine in the world, which also means that, well, the drug policy in the United States is just so bad because they don't treat drug addicts as sick people, for those who have an addiction. Okay, and I'm very liberal on these things. I mean, for those who do it for recreation and leisure, it's good for you. But those who have actually an addiction, this is sick people that deserve to be treated, not incarcerated. It's like an alcoholic. You send them to Alcoholic Anonymous, not to jail. Well, you should, right? And with the excuse of controlling drug trafficking, not eliminating it, because the U.S. government makes just so much money with cocaine and the people that they put in jail, because they make so much money putting people in jail here. So they decided to use Costa Rica and their influence. Well, it was not necessary to use that much influence. The current president just serves America. She doesn't give a peanut about Costa Rica or what we, the people, want. So the Costa Rican Congress authorized the U.S. Navy to start performing police duties in Costa Rica. When the Army was abolished in 1948, and it was set in 1949 Constitution, they included a second paragraph in Article 12 that says, "For the maintenance and conservation of public order, there shall be sufficient police forces." Okay, this means two things. That it has to be police, and police is civilian. Moreover, and I always bring this fact when I speak in America, cops in America were used to be called peace officers. Some of you might remember. They were not police, they were peace officers. And the second part of the story is that we should have, if we had sufficient police, we don't need nobody to come. The Constitution does not authorize bringing other police or other bodies. It says we should have sufficient police. And we actually do have sufficient police. It's a very peaceful country. Or at least I thought it was a very peaceful and quiet country, but after seeing that we need 12,000 soldiers, 45 warships, 2 carriers, 180 Black Hawks, and 10 Harrier crafts, I'm going to ask for asylum in the United States because it's so dangerous right now in Costa Rica. You just don't go anymore. Monkeys are fleeing away. You know, birds. So the whole thing was just a hoax. Like, it was not drug dealing, it was no security, because they are not coming inland. They are staying in the waters. So what sort of security are they bringing if they are where the fish are? No, so
they're protecting you from the Somali pirates.
Maybe, I don't know. The thing is that the rationale, it just doesn't make sense. I mean, I'm not a doctor in law. I just got my grade. I never had time to get a master's or anything like that. I engaged into working and then going to Japan, and then I had to make a living someday, you know, so I had to start working, and I opened my own office that I still run until now. But they went to Iraq, the most dangerous regime on earth, and they took over the whole damn country in 3 weeks. The U.S. government could not take over Baltimore in 3 weeks if they wanted. And moreover, they found Saddam Hussein in a damn hole in Iraq, and you telling me that with 180 Black Hawk helicopters you cannot find a cocaine plantation in Colombia? It just doesn't make any sense. God's sake, it just doesn't make any sense. Anyway, so I went to the Supreme Court and I filed suit and I said, okay, there are several things going on. First, the permit was granted based on the 1999 Joint Patrolling Agreement between the U.S. and Costa Rica, which authorized U.S. Coast Guards to help surveilling the waters, Coast Guards. Yeah, under the U.S. Code, the Coast Guards are part of the military, but let's say that they are not. Just let's give them that point, okay. The agreement had a 10-year duration, so it expired in 2009. This permit was given in 2010. Now, this is where the court blew it. The agreement said that if the government of Costa Rica wanted, they could extend the agreement for 10 more years. And the only thing they had to do was the President of the Congress sending a letter to the State Department saying we want to renew the agreement 10 more years. So the court recognized in the ruling that that request was never done, which means that the treaty was expired. So I claimed that. And then I said, well, it's clearly a violation to the right to peace because the warship is a war thing. Soldiers are weapons of war. They are not just people because they twist their minds and things and, yeah, I'm American, I'm going to kill you all. This is weapons of war. They are weapons of war. They are trained to kill. They are trained to kill indiscriminately. And that it was also a violation on Article 12 of the Constitution, not only for the abolishment of the army, but because we should have sufficient police forces. The court rejected the suit, saying that even though the permit had expired because there was no extension, it was still in vigor. If somebody can explain me that, I would really appreciate it because I've been trying for 3 years and I haven't been able to do so. And then they said that the maintenance of peace and security, and it reminded me George Bush saying that we are willing to give up our freedom in order to preserve our security. As you might remember that he said that many times. And I don't know if that was the general feeling of the American population, but I hope not. So the case was rejected, and because I'm so stubborn, I took it also to the Inter-American Commission of Human Rights, also on the grounds that there was a denial of access to effective justice. You know, because I have the right to a prompt and effective judiciary, and the judiciary was not effective in this case because they did not apply the law correctly, and which is the definition of an effective judiciary, that one that is functional. So after that came the Winsick case. And this is just disgusting, but oh, Arias is disgusting. So some of you might have heard about SOA Watch, School of the Americas Watch, which is an organization led by Father Roy Bourgeois that is meant, or its goal is to shut down the School of the Americas, because they have trained 14 dictators in Latin America and all the guys that work with these dictators. So because the US government is not listening to Father Roy in his claim to cut funds to the School of the Americas, they had this brilliant idea, okay, there is no school if they have no students. So let's go to every country and let's talk to the government and request these governments to withdraw their cups from the School of the Americas. Smart guy. So they succeeded in 4 countries, and then they came to Costa Rica in 2007. And they sat with Oscar Arias and Fernando Berrocal, who was the Ministry of Security at that time. And Father Roy started talking with Arias, come on, man, like, you're a Nobel Peace Prize, and it's dictators, and it's so bad, and how can you do that? And I don't know, he brought the saints and angels and everything down. So Arias said, oh, all right, like, you're right, I cannot expose my reputation as a peace laureate and so on. So he came out on the media, just like the French president, and said, okay, after the 3 cups that we have currently in training at the School of America, we will send no more. And he was so proud with his medal of the Nobel Peace Prize and a dove and getting pictures and so on. And this created an international obligation, just like the French President Declaration. Same thing. But the U.S. Embassy didn't like that stuff, because they always need to have a backup plan when the wrong guy is elected. And that backup plan is a coup. They just had it in Honduras. And Honduras still doesn't have its constitutional president until now. It's unconstitutional, the current government of Honduras. And Arias participated on that, but I'm not going to talk about that. Only if you want. So the U.S. Embassy started talking with Berrocal, and they said, man, like, Arias blew it, man. Like, this was not within our plans, and we got to keep sending cups to the School of the Americas. So they sent Berrocal to the School of the Americas to try to give him the excuses to justify that it was an institute for peace and human rights and democracy. And Berrocal came back to Arias and said, come on, man, we got to yield to the U.S. Embassy interests, and we got to do. And they had this brilliant plan. These guys are just amazing. And it came out on WikiLeaks. The sad part of the story is that we knew about this because of WikiLeaks. They said, okay, let's do this. I, Fernando Berrocal, Ministry of Security, I'm going to send you a letter as president requesting you to authorize me to send cups again to the School of the Americas. And you will not reply, and I will take that as a yes. So if the administration would work like that, can you imagine the amount of letters that would be sent never to be replied? Just can you imagine the amount of letters that every day, bunch of letters, just don't reply, man, and we're going to take that as a yes. Are you mental? Like, what is going on? And this came out on WikiLeaks, right? So they illegally and in secrecy began resending cups to the School of the Americas, just 6 months after he decided not to keep doing so, in violation of this international obligation also. So I went back to the court, and I argued basically what you're seeing there. The constitutional jurisdiction law in Costa Rica is very simple. Proceedings are very simple. They have basically 3 types of legal actions. The first one is the habeas corpus, which comes for illegitimate detentions, you know. Show the body, as is the literal meaning from Latin. Habeas corpus, habeas and corpus, show the body. We have the recurso de amparo, and it has no translation into English. It's a sort of injunction, but it's a remedy created in Mexico aimed to give prompt and quick protection to fundamental rights. It's sort of as an injunction. And we have the unconstitutionality action. Okay, now, because the court has the goal to protect human rights and fundamental rights, the proceedings are very easy. So in Costa Rica, anybody can file a suit for a violation of a fundamental right, anybody, regardless of the age, regardless of the migratory status, regardless of the nationality, regardless of anything, because the Constitution says that every person has the right to submit a recurso de amparo. And again,
Do you file on behalf of yourself and not a client?
no, everything has been done on my behalf. Yeah. And so everybody has the right to submit a recurso de amparo. And the unconstitutionality action is the only procedure that has some technicalities because, well, it's aimed at declaring the nullity of a law or a decree, you know, something that affects everybody. So it's a little bit more careful on that. However, the court says that whenever the wrong suit is submitted, but it actually, in reality, is a recurso de amparo, the court will transform the suit automatically into a recurso de amparo and they will try it. Because if they reject it and they order the people to get back the same paper with a different wording, because the contents and the merits are the same, then justice will not be prompt. So I submitted an unconstitutionality action because I still think that that was the appropriate mechanism to submit. Well, the court rejected the suit saying that you have to do and submit a recurso de amparo. They did not convert the suit. And it took them 13 months to do that. So I got the ruling, I went to my home, I opened the document, I changed unconstitutional action by recurso de amparo, I printed again and submitted again. And I resubmitted it in September last year. I have not heard about the case since then. The court don't want a rule. I don't know if they are going to find another argument in order to not to try my cases anymore. Because they have been sued in the Washington, at the Inter-American Commission, and like I'm so stubborn that they are running out of options and excuses and possibilities. So anyway, this case is pending. This case is pending, and I hope that I win, not because I win, but because we all win, even people who doesn't live in Costa Rica. And after this case, I'm just waiting for the government to do another brilliant thing, because I will keep suing. It doesn't cost me $1 to file these suits. It costs my time, but I got time. Well, I think I have time. My clients haven't complained yet. And now the question is there really a right to peace internationally? So I've been going to Geneva for the last 2 years to the Human Rights Council, and we are working on making a declaration on the right to peace. It is shocking to listen to the representative of the European Union, Canada, and the United States coming out and saying we do not recognize the existence of such a right. I'm quoting. Yeah, I'm not just rephrasing. No, they say we do not recognize the existence of such a right, and we do not recognize that peace can be a right. They say that there is nothing in international law that establishes such a right. These are the UN Human Rights Council in Geneva, but then I went to the UN Charter. And for this ends, to practice tolerance and live together in peace with one another as good neighbors and to unite our strengths, to maintain international peace. Article 1, principles and purposes, to maintain international peace for the prevention and removal of threats to peace and the suppression of acts of aggression and other breaches to peace. Adjustment or settlement of international disputes or situations which might lead to a breach of the peace. Article 2, with the principles, all members shall settle their international disputes peacefully. All members shall refrain in their international relations from the threat or use of force. I don't know if these guys have read the UN Charter before going to the UN, but I think not, because it's clear that there does exist. I mean, one of the international public law has two basic and fundamental documents: the Vienna Convention on the Law of Treaties and the UN Charter. It's the core of international public law. And the core of international public law says that peace is an international, at least, value. Let's say we're going back to the early Costa Rican Constitutional Court, but still as a value, it remains as a parameter of legality of the acts under international law. Say it right, say it value, it has the same practical effect. It's a boundary set to the states in their activity. So it does exist. There is no other principle or value that has been reaffirmed so many times as the value of peace. I mean, every single war that has ended with an agreement that requires to live in peace. Every single one. Every single international human rights instrument is aimed at social peace and justice. Every single one. There is no other topic that has been treated more in the UN than the topic of peace. So it does exist, that right. We don't need that declaration that we are working on. I mean, if we make it, it's going to be good. But we don't need it. As we don't need a lot of declarations that we are working on, because it has already been said and it has already been stated. How many declarations do we need to understand that the use or threat of use of force is forbidden? What do we need is to send these guys to school so they learn to read. That's what we need. That's the importance of public and mandatory education paid by the state, you know. And I'm going to end here because I'd rather listen to your questions and see what you really want to hear, because I might have said a bunch of things that you don't want to hear. And these are fundamental questions that we got to ask ourselves, particularly the last question. What is preventing you to try to do something? Just to try. So when I submitted the first suit against the war on Iraq, I really didn't know where were the boundaries set legally. You know, when did international law apply or when it didn't apply? I didn't know. So my argumentation in the suit was an act of ignorance, if you want to call it that way. I didn't know where the boundaries were. And it was fantastic to be ignorant at that moment, because then I requested something that I didn't knew that historically was not possible. I didn't know that. And it changed the whole legal system in Costa Rica. It changed our history, if we want to see it that way. Or we reverted a very bad decision that would have changed our history. It was an act of ignorance. Now, when I filed the second suit, I knew where were the boundaries. And then I had an act of rebellion. I was not satisfied with the standard, with the bar, and the boundaries. And I did not find anything in the law setting those boundaries there. Those mental boundaries in our heads. But I'm not, I only behave and comply with regulations when I'm at an airport. Because I have no other choice. But I just keep trying to find ways to push the bar wherever I find that this bar has no grounds. Specifically in the topics that I work, that is mainly peace and human rights. I try not to work on other areas because it's not possible and it's not responsible, to try to tackle every single issue that we disagree on. We got that's something that we're doing good, so we rather stick to it instead of blowing it up. So what can we do? What can be done? Or what do we have to do so we can actually do what we want to do? For instance, I want to change that bulb. But as I am this tall, I don't reach the bulb. So what do I have to do to reach the bulb? Well, I got to bring a ladder. The ladder is the judicial mechanisms. So wherever I don't have a ladder, I gotta get a ladder. Because if not even if I'm a Spot Webb, that guy that used to jump a lot in the NBA, I'm not gonna reach that bulb. Not even if I bring LeBron to put me up, I'm not gonna reach the bulb. So what do I have to do to reach the bulb? And I have been, now that I understand a few things and I understand but disregard other things, I try to think on my activity as stepping stones. So how can I make this so I can use it later in something bigger? And this means discriminating on whether it is strategic at a specific time to try certain case, or if it's better to wait a little bit, because if I miscalculate something, I'm going to miss a stone. And this step that I got to do might be fundamental because I don't know what's going to happen in the future. I had no idea what was going to happen in 2003 when I filed the suit. I had no idea what's going to be here, for instance. I had no idea I was going to Japan to work and live for a year and a half. I had no idea I was going to be at the UN Human Rights Council. Especially coming from a small country like Costa Rica, where we have very, very limited opportunities. This act of ignorance and naiveness and rage that all combine in this case, because I was very upset when I was writing the first suit, changed my life in unimaginable ways. And not only my life, it changed the life of other people also because of the effects of these things. I mean, we are not having people killed by nukes made in Costa Rica so far, which is good. I always tell people the same thing. I didn't go to no fancy school. I didn't get a master's. I never get a doctorate degree. I just got my degree. There is way, way, way smarter people out there. I don't think of myself as nobody who is smart or brilliant or anything like that. I think that what I did could have been done by any other of my classmates. But they didn't. And I don't know why they didn't. So these are the questions that I want to leave to you, because I might not be able to change the world, because I cannot, but I might change my surroundings. And each of us can change our surrounding, our environment. And if by this talk, one of you makes a change in our mindset, a little bit, just one bit, you know, a 0 for a 1 or a 1 for a 0. If this small change happens, I'm going to be happy, because I already changed the environment, my surroundings. And I hope that you can do that yourselves. I'm not saying that just go sue everybody, but change your surroundings in whatever ways you actually can do it. Because as I said before, I was able to do this because the system allowed me to do this. Not everybody's in the same position and not everybody's in the same situation, but within your possibilities, what changes can you do? Can you make this peace reality? Or you rather not live in peace? I mean, I was born and raised in a peaceful country. I had a fantastic childhood. Fantastic. No crime, good education. Kids would play on the street until the sun is down. No kidnapping, and everything has been destroyed with time and with IMF and these crazy policies that tell us that we gotta buy and produce and become employees of big corporations and not the owners of our own destiny. We are trained to, you know, in the good old days, even in America with the American dream, you were pushed almost to become entrepreneurs, you know, to go out there and to dare, you know, the reality, and to try to become the masters of your own ship. But now, my generation, we are trained to be employees. And I hate that. So I refuse to be an employee of no firm, of no transnational. It has it has a cost, and it has a toll, but I'm happy to pay it because I'm free. Absolutely free as I was when I was a kid playing until sundown. So anyway, I'm going to shut up and let you make your comments or questions, and please be free to ask whatever you want to ask. I'm single, 32, like whatever you want to ask. I have a girlfriend, but I'm still single. So whatever you want to ask, please feel free. As you saw, I'm not a fancy guy or anything like that, so just go ahead.
Thank you so much, and let's stay in touch.
Thank you.